Hello everyone. The topic of this lecture is digital signatures and the digital signature file format XAdES in particular. Now, we already know how to digitally sign data using, for example, the RSA or ECDSA algorithms. However, while signing on its own is quite a straightforward cryptographic operation, we need much more than that to use digital signatures as a replacement for our handwritten paper signatures. In this lecture, we will look at the digital signature legal framework used in the European Union and how this legal framework is implemented in practice. What technical means are used to achieve it? So let's start with the legal framework. So in the European Union, we have this eIDAS regulation, which is automatically binding to all EU member states. So what does it say? In Article 3, it defines three types of electronic signatures. The first type is a simple electronic signature, which means data in electronic form which is attached to or logically associated with other data in electronic form and which is used by the signatory to sign. As you see, this definition of electronic signature is very broad. It can mean anything. It does not require the use of any cryptography. For example, when you write your name under an email, that can also be interpreted as a very simple form of electronic signature. When you click in some checkbox to agree to the terms of service on some website, this could be an electronic signature as well. The eIDAS defines something more advanced, which is called advanced electronic signature, which means an electronic signature which meets the requirements set out in Article 26. To summarize, the requirement is that this signature has to be uniquely linked to the signatory. Now, this type of electronic signature actually requires the use of public key cryptography because in reality, it is very hard to achieve this property without the use of cryptography. So, this advanced electronic signature is what is usually meant by the term digital signature. It is an electronic signature which uses public key cryptography. eIDAS goes even further and it defines the highest level of electronic signature, which is called a qualified electronic signature. Now, the qualified electronic signature means an advanced electronic signature that is created by a qualified electronic signature creation device and which is based on a qualified certificate for electronic signatures. The qualified electronic signature creation device here means a hardware security module. Smart cards are used in practice. And this qualified certificate means that the signatory's public key has been certified by a trusted certificate authority. So, if these three criteria are met, only then it can be considered a qualified electronic signature. Okay? Now, these two types of signatures are not too interesting because the use of these signatures is not regulated by the regulation. In this course, we will focus on the qualified electronic signature, as it is legally regulated, and eIDAS in Article 25 rules that a qualified electronic signature shall have the equivalent legal effect of a handwritten signature. So, if we sign something using qualified electronic signature, it should have the same legal effect as if we had signed it on paper, and this applies in the whole EU. We can create such a qualified electronic signature using the ID card or smart card, for example. So when we are talking about the digital signatures used in Estonia, we are talking about qualified electronic signature. The term digital signature is the Estonian local term which was invented before eIDAS. Actually, it would be more appropriate to use the eIDAS term qualified electronic signature. Anyhow, so using your Estonian ID card, you can create qualified electronic signatures. The Estonian state provides open source software that can be used to create and validate digital signatures. The software is called DDOC client, and you can see it here. Here you can see a signature given by Kersti Kaljulaid, the ex-president of Estonia. She has digitally signed some legal act, this file here. What we see here is the name and personal identification code extracted from the signatory's certificate, and the sign-on time showing when the signature was made. And here we can add our signature as well. So the software will check the validity of the signature and show signature is valid if all the tests pass successfully. Now, what is interesting to note here is that no technical standard exists that would describe in detail how to technically verify the validity of a digital signature. The developers of this software have implemented their validation algorithm as they understand it, and basically the whole legal system relies on the validity status shown here to decide whether the signature has legal effect or not. There have been cases when the developers have updated the validation algorithm, and suddenly a signature that was, for example, valid yesterday is now considered as invalid, and vice versa. We will look at the digital signature file format and how to validate it, but let's first discuss the legal effect of a qualified electronic signature. So, the law says that qualified electronic signature has the same legal effect as a handwritten signature. But what does it mean in practice? Why would we need a handwritten signature at all? What does a signature provide us that we could not do without it? Well, we could say that a signature can be used to sign contracts. For example, enter into business transactions. However, the truth is that most of the contracts do not have to be in writing to be in force. Civil laws give freedom for the form how parties enter into transaction. For example, when we buy something in a shop, we are not required to sign anything. We enter into transaction with a concludent action. So our transaction will be valid without any signatures whatsoever. And this also applies to digital signatures. In the majority of cases where we use digital signatures today, a digital signature is not required. Therefore, these transactions would be valid even if it turns out that the digital signatures are not valid. There are only a few types of contracts that have to be in writing to be valid. Such contracts include contracts of consumer surety, contracts relating to the purchase of the right to use the building on a timeshare basis, long-term holiday product contracts, exchange system contracts, agency agreements, and life annuity contracts. Most likely, you have never heard of these before. And then there are form requirements. For example, to get married, the application has to be not only in writing and signed, but has to be submitted in person, on site. So there are transactions where even a signature is not enough. A slight different picture is in the public sector when issuing legally binding documents. For example, a signature must be used to sign legal acts. So here, in most cases, the existence of a signature will be a critical prerequisite for the validity of a document. If some decision does not have a signature, it is not binding to the relying parties. The reason why signatures are widely used in practice is because signed documents can be used as evidence in court in case some dispute arises later. Now, a tricky question to you. Can unsigned emails be used as proof in court? Well, yes, they can, but only as long as the other party does not contest the authenticity of these emails. And here the crucial question is whether there is any benefit of using qualified electronic signature over unsigned emails as evidence in the court. And there should be, otherwise, what's the benefit of having all the complexity around qualified electronic signatures if they did not provide a higher evidentiary value, right? Now, eIDAS itself does not define the evidentiary value of qualified electronic signature. Each member state has to decide on their own what evidentiary value the qualified electronic signature will have. This is what the Estonian Code of Civil Procedure says about contestation of authenticity of electronic documents. It says that authenticity of an electronic document bearing a digital signature may be contested only by substantiating the circumstances which give reason to presume that the document has not been prepared by the holder of the digital signature. So, if a judge runs a signature through the DDOC software and the software shows that the signature is valid, it will be recognized as authentic, and the only way to repudiate it is to prove that it was not you who signed it. But how would you do this in practice? What could be these circumstances and how could we substantiate them in practice? If I suddenly fetched from my pocket some contract digitally signed by you, but you don't remember signing it, how could you repudiate it? And this is a very important question to understand how strong the qualified electronic signature as evidence actually is. For instance, if there is a signature made in your name and you know for sure that you have not signed it, but you are held liable for that signature, then it would be very dangerous to have an ID card or smart ID, as none of us can guarantee that our computer or mobile phone could never be hacked to forge a signature in our name, right? But on the other hand, if we could simply shrug off the liability by saying that we are running Windows XP without antivirus and hence our computer was probably hacked and the signature was forged, then qualified electronic signature on its own would have a very weak evidentiary value, and relying parties would need some additional evidence to prove that we willingly entered into the transaction, right? So today, we actually don't know the answer to this question. There have been only a few cases in the court where a digital signature was repudiated by the signatory, and these were easy cases. In one case, there was a guy who admitted that he used another person's ID card to create a signature. And in another case, there was additional evidence about the signatory's will to enter into a contract. So, no simple answer today. Perhaps we will see when some larger scale fraud starts to appear. But all right, let's talk about the qualified trust service providers, or QTSPs. The eIDAS regulation doesn't use the term certificate authority. It uses a broader term called qualified trust service provider. But in practice, when issuing certificates, they perform the same function as a certificate authority. eIDAS says that only a qualified trust service provider may issue qualified certificates for electronic signatures. That is, to bind the signatory's identity with their public key. So, how does one become a qualified trust service provider? Qualified status is granted by a supervisory body designated in each EU member state. In Estonia, this supervisory body is the Estonian Information System Authority, or RIA in short. Article 22 of eIDAS requires that each member state shall establish, maintain, and publish trusted lists, including information related to qualified trust service providers for which it is responsible, together with information related to the qualified trust service provided by them. The Estonian trusted list signed by RIA is available at this URL in a machine-readable XML format. It contains a list of all the qualified trust service providers and their CA certificates. And it contains a full history, recording when the qualified trust service provider was added, when removed, and so on. So each country issues such a trusted list for qualified trust service providers under their supervision. Then there is a European Union list of trusted services, or trust list, signed by a European Commission employee. This list contains links to the trusted lists of each member state and the public keys of all supervisory bodies so that the authenticity of the member state trusted lists can be verified. Effectively, what we get is a European Union level public key infrastructure where this EU list of trusted lists is the root trust anchor. The Estonian DDOC software uses this trusted list when validating a signature. Therefore, theoretically, it should be able to validate signatures created in any member state, as long as they comply to the eIDAS file format standards. There is a nice web front-end which can be used to browse the trusted lists of each member state. If we click on Estonia here, we can see that there are two qualified trust service providers registered in Estonia. So the CA SK-ID Solutions AS here is the CA that issues certificates for the Estonian ID card, mobile ID, and smart ID. Let's talk about qualified electronic signature creation devices, or QSCDs. Remember, for a signature to have the qualified electronic signature status, it has to be created using a qualified signature creation device. In practice, these signature creation devices have been traditionally implemented using smart cards. Smart ID is an exception here, as it is a server-assisted hybrid solution. eIDAS in Annex 2 sets several security requirements that qualified signature creation devices shall ensure by appropriate technical and procedural means. That is, A, the confidentiality of the electronic signature creation data used for electronic signature creation is reasonably assured. The signature creation data here is the private key. It has to be reasonably protected, whatever is meant by reasonably. B, the electronic signature creation data used for electronic signature creation can practically occur only once, meaning that there should not be any copies, right? Each signatory should have a unique private key. And C, the electronic signature creation data used for electronic signature creation cannot, without reasonable assurance, be derived, and the electronic signature is reliably protected against forgery using currently available technology. Meaning that the security level of crypto primitives used is high enough such that the private key could not be calculated from the public key. So, if you remember the Estonian ID card ASiC-E generation flaw, this was a good example where this requirement was not fulfilled, but yet the Estonian government made the political decision to continue using the affected ID cards for several weeks after the flaw was discovered. D, the electronic signature creation data used for electronic signature creation can be reliably protected by the legitimate signatory against use by others. This requirement is usually achieved using the PIN code mechanism. Even if other persons have physical access to our ID card, without knowing the PIN codes, the signature creation data cannot be abused. As you see, the regulation tries to avoid using specific technical terms here. And this is done to provide flexibility in case some new technological solutions are invented. Very good. So these are the requirements. But how can we know whether some device, for example, our ID card, satisfies them? eIDAS requires that these devices or products have to pass the security certification according to common criteria EAL4+, Evaluation Assurance Level 4 Augmented. And the eIDAS implementation decision points to a specific common criteria protection profile that must be used to evaluate the security of secure signature creation devices. So, if some vendor wants to provide these devices to the market, it has to choose an evaluation facility which will evaluate the security according to this standard. Of course, the vendor will have to pay a lot for this evaluation process. Then, based on the evaluation report, a certification body will grant qualified signature creation device status to the device. There are no evaluation facilities or certificate bodies in Estonia, so this process has to be done abroad. The closest certification body probably is BSI in Germany or ANSI in France. Now, when a qualified trust service provider issues a certificate, it has to specify in a certificate extension whether the private key is stored on a QSCD. So it is the task of the qualified trust service provider to assure that the device where the corresponding private key is stored conforms to these requirements and has passed the common criteria certification. In practice, only the latest generation of Estonian ID cards issued since 2019 have passed the security certification process. None of the previous ID cards have been certified. This is because before eIDAS came into force, the requirement that the device have to be certified wasn't there. In practice, there were a few people in RIA who decided, based on their expert opinion, that the ID cards used in Estonia conform to these requirements. This was a very convenient and quick process, but it missed a serious security flaw in the ID cards that were issued in 2011. Namely, that the PIN verification check was not implemented correctly, allowing creation of signatures without entering the PIN code. Of course, security certification cannot guarantee the absence of security flaws either. For example, the notorious flawed Infineon ASiC-E generation implementation was security certified by BSI in Germany, and here we can read Infineon's press release, which states that this software function was certified by BSI in Germany, but no mathematical weaknesses were discovered during the certification processes. So, this is an example of a failure in the certification process. But of course, some security testing is still better than none, right? Now let's talk about the validation of a qualified electronic signature. So, what are the legal requirements that a signature has to satisfy to be recognized as a qualified electronic signature? eIDAS Article 32 specifies that the process of the validation of a qualified electronic signature shall confirm the validity of a qualified electronic signature provided that, and several points. A, the certificate that supports the signature was, at the time of signing, a qualified certificate for electronic signature complying with Annex 1, which makes sense. B, the qualified certificate was issued by a qualified trust service provider and was valid at the time of signing. And this also makes sense. If the signature was made after the certificate expired or was revoked, such a signature should not be valid, right? C, the signature validation data corresponds to the data provided to the relying party. This means that the signature can be verified using the public key specified in the certificate. D, the unique set of data representing the signatory in the certificate is correctly provided to the relying party, meaning that personal data in the certificate should allow the signer to be identified. In practice, the certificates contain the name and the personal identification code of the signatory, so this should not be a problem. E, the use of any pseudonym is clearly indicated to the relying party if a pseudonym was used at the time of signing. This is not too relevant as pseudonyms are not used in practice. F, the electronic signature was created by a qualified electronic signature creation device. This can be easily checked as there will be a flag in the certificate stating that the corresponding private key is stored in a qualified signature creation device. G, the integrity of the signed data has not been compromised, meaning that the data has not been modified after the signing. H, the requirements provided for in Article 26 were met at the time of signing. To remind you, Article 26 described requirements for advanced electronic signatures, so this is a requirement that cryptographic algorithms were not broken at the time of signing. Very good. So these are the requirements for the signature validation process. Now, as you see, there are three requirements which involve time. For example, this requirement B, that the qualified certificate was valid at the time of signing. So, how can we establish whether the certificate was valid at the time of signing? For instance, if I provided to you a signature and the corresponding certificate which is now already expired, how would you figure out whether the signature was created before the certificate expired and therefore should be recognized as valid, or it was created after the certificate had expired and therefore should not be valid? To solve this problem, we somehow need to figure out whether the signature existed before the certificate expired or was revoked. And this is where we come to the concept of trusted timestamping. eIDAS provides a definition of electronic timestamp, which means data in electronic form which binds other data in electronic form to a particular time, establishing evidence that the later data existed at that time. What it means in practice is that we have some additional trusted third party whom we can send some data, and this party will return some signed timestamp. The PKI-based timestamp protocol is described in this RFC. We will not go into details. It is very similar to the OCSP protocol, but essentially we can send some hash value to the timestamping service, and the service will return a signed statement of the timestamping authority, or TSI, which confirms that this data was presented to me at this time. And this statement is signed by the timestamping authority. There are a couple of requirements that a timestamping authority must follow. The timestamping authority must use an accurate time source. The clock has to be always kept synchronized. Another requirement is that the timestamping authority must log issued timestamps and hand them out if requested. This way, even after the TSI signing key gets compromised, there is some offline evidence to verify that a particular timestamp was indeed issued. Would be nice if the issued timestamps were logged using some hash chain or blockchain, as this would bind them to specific time. But this, unfortunately, is not a mandatory requirement for TSAs. Under eIDAS, the timestamping is regulated as a separate trust service that can be provided by qualified trust service providers. What is important to note is that eIDAS grants the presumption of authenticity for qualified electronic timestamps. Article 41 states that a qualified electronic timestamp shall enjoy the presumption of the accuracy of the date and the time it includes, and the integrity of the data to which the date and time are bound. So, if we submitted to court a qualified electronic timestamp, the court would have to presume the correctness of this statement. The burden of proof would fall on the other parties to prove the opposite. But I have no idea how in practice anyone could prove the opposite. For example, that the TSA has issued a timestamp containing a backdated time, because TSA is not required to implement security measures that would prevent TSA from backdating their audit logs, for example, by using a hash chain, right? But anyhow, how can we use a timestamp in digital signatures? So, to prove that a signature was created before the certificate expired, we have to timestamp the signature before the certificate expires or gets revoked. And that is exactly what is done when creating a digital signature. If we look at a standard digital signature file container, we can see that it has to bundle together several data fields. The signature value contains a cryptographic signature over the files to be signed, signatory certificate, some optional metadata such as role, city, and so on, and signatory's computer time at the time of signing, a purely informative field. This signature value now has to be timestamped. It is sent to a timestamping authority, which returns a signed response binding the signature value to the specific timestamp, proving that the TSA saw this signature value at the time specified in the timestamp. The timestamp is then attached to the signature container. So, what does it prove? It proves that the signature was given before the time specified in the timestamp. And if this time is before the expiration time of the certificate, then we know that the signature was given in the validity period of the certificate. Right? Right. Very good. But that is not enough, because certificates can be revoked before expiration. So, in addition to prove that the certificate was not expired at the time of signing, we as well need a proof that it was not revoked at that time. And we can use an OCSP response for that purpose. The validity status of the signatory certificate is checked, and an OCSP response proving that after the signature was timestamped, the certificate was still valid is attached to the signature container. So, this will prove that at the time of signing, the certificate was still valid. A crucial thing here is that the OCSP request must be made after obtaining the timestamp, because an OCSP check made before the timestamp was made will not be able to prove that after the signature existed, the certificate was still valid. Makes sense, right? Until recently, the Estonian digital signature software missed this check and accepted signatures that have been created after the certificate was revoked. And it turned out that the same flaw was also contained in other signature verification libraries used all over the European Union. Here you can see a video that demonstrates the problem. A good example is the digital signature verification software used in Latvia. It still ignores this check. So, if you verified such a signature with the Estonian software, it would show that the signature is not valid, while the Latvian software would return the validation result valid. The reason why the Latvian digital signature creation software returns valid is because for several years the software did the signing process in the wrong order. It first obtained the OCSP response and only then the timestamp. So, if this check was enabled, it would return invalid signature status for who knows how many digital signatures created in the past. So, to avoid such an unpleasant experience, software developers made the decision to ignore the legal requirements and pretend that such signatures are valid. Now, since the court will decide whether the signature is valid based on the result returned by the software, a court in Latvia will consider such a signature valid, while a court in Estonia will consider it not being valid. Of course, such a situation should not occur because all EU member states should apply the same validation algorithm when validating a qualified electronic signature, right? But okay, let's assume that the signature container is constructed in the correct order. So these two statements will provide proof that the signature was given before the certificate expired or got revoked. But there is still one case that this scheme cannot handle. Namely, this scheme is unable to verify whether the signature was made while the certificate was not suspended. Certificate suspension is a mechanism that can be used to temporarily revoke a certificate. It means that the certificate can be revoked, but later the revocation can be removed, making the certificate valid again. For instance, before you receive your ID card, the certificates of your ID card are in a suspended state. The suspension is terminated when you receive the ID card. This means that if an attacker can get a hold of your ID card while the certificates are suspended, the attacker can create this cryptographic signature, and later when you get your ID card and terminate the suspension, the attacker can obtain a valid timestamp and OCSP response, making the signature valid, while according to law, it is not valid because actually the signature was created when the certificate was suspended. So this suspension mechanism, in a way, is a flaw which prevents the validation of a digital signature according to the legal requirements. Theoretically, it is possible to use this knowledge to challenge any digital signature created using a PKI scheme that supports certificate suspension. But as far as I know, no one has done it yet. And not all PKI schemes support certificate suspension. For example, in Smart ID, the certificate cannot be temporarily suspended. It can be only revoked. So the signatures created using Smart ID are not affected by this problem, while the signatures created using the ID card are affected. Now, what about the long-term validity? So for how long can we verify the validity of such a digital signature container? Will we be able to verify such a digital signature, let's say, 10 years after the signature was given? What if the private key of the signatory gets compromised in the meantime? Is this a problem? This is not a problem, because the timestamp and OCSP response will prove that the signature was created before the private key was compromised or the signature algorithm became weak. But for how long can we trust the timestamp and OCSP response? The problem with the OCSP response is that the OCSP signer certificate is usually valid for a very short period. It could be just a few days. Can we trust the OCSP response after the OCSP signer certificate has expired? Can we trust the timestamp after the TSA certificate has expired? The verification algorithms in practice assume that the OCSP and TSI certificates can be trusted forever, as long as the crypto algorithms that were used to create the signature are still considered strong. If we suspect that the OCSP response might have been forged, we can contact the CA and ask if the signer's certificate was valid at some specific point in time. If we suspect that the timestamp is forged, we can ask the TSI whether it issued the specific timestamp. TSIs have to maintain the record of all issued timestamps for several years after the TSI certificate expires. If a TSI or CA goes bankrupt, they have an obligation to hand over all audit records to the National Archive, so the audit logs are preserved. One way to extend the validity of a digital signature is to re-timestamp the whole thing from time to time. So before the timestamp and OCSP certificates expire, we could re-timestamp the entire container. This way, it will be possible to prove that these signatures existed before the corresponding certificates expired or the crypto become weak. The security of hash functions is very important here. No timestamp will help us if the hash value that we timestamped does not uniquely identify the data that we timestamped, right? However, for long-term validity, only the second preimage resistance of the hash function is important. The good news is that second preimage resistance is a quite strong property, as it holds even for the cryptographic hash functions that today have been found to not be collision resistant. So we should not worry about second preimage resistance too much here. Now, in practice, the importance of long-term validity may be overestimated, as most likely nobody would notice and care if it turned out that a few years after creating a signature, it can no longer be verified, right? The time of signing is another issue worth discussing. So, what do you think? Where does this signed on time come from? Well, it is the time from the timestamp, and as you know by now, the time in the timestamp does not specify when the document was signed, but gives proof that by this time the signature already existed. So, this wording signed on is not very accurate. The problem is that there is a widespread misconception in the society that a digital signature provides some cryptographic proof about the time of signing, which in fact is not the case. So, as you see here, these data fields, timestamp and OCSP response, they are not under the signature. So, it is easy for someone to remove these fields and obtain a new timestamp and a new valid OCSP response, assuming that the signature certificate is still valid. Now, to give you an example, here is an example of such a modification. Here you can see the original container and timestamp, and here you can see a modified container that has the timestamp renewed. And by the way, here is a demonstration video of how the modification was done, if interested. But is this a problem in practice? One problem is that it is a common practice to not specify dates of legal significance inside the contract, but refer to the time of signing. For example, here is my UT employment contract, which does not have an explicit date here, but refers to the date in the digital signature. So this time here, since it can be renewed, it creates some interesting legal implications since we can effectively renew the time of the employment contract, right? We have asked the developers of the Estonian DDOC software to modify this misleading wording such that it would indicate the unreliability of the time shown here, but so far nothing has changed, unfortunately. Let's look at the actual digital signature file formats used in practice. eIDAS implementation decision specifies several advanced electronic signature file format specifications to be recognized by public sector bodies in the whole European Union. There are three types of file formats. The first is XML-based XAdES signature format. XAdES stands for XML Advanced Electronic Signature. So this is the format that is used in Estonia, and we will work with it in the homework. Baseline profile here means that it is a subset of the standard. So XAdES is a very huge standard with many options and features. This profile restricts possible features that have to be supported. And even with this restricted baseline profile, there are still too many possible options, and in practice we see that each country implements the file format a bit differently, which unfortunately leads to interoperability issues. Then there is CMS XAdES format, which basically carries the same data and has the same data fields as XAdES, but instead of XML, this one encodes data using AS1 derencoding. And to be honest, in practice, it is much easier to work with AS1 derencoding than XML because implementing XML parsing is not trivial at all. And finally, there is the PDF-based PADES format. This is quite different from the previous two because it can be used to sign only PDF files, which is a quite limiting factor and hence not a very interesting format. So, while in the case of PDF signatures, the signature is embedded into a PDF object, the question is, how do we bundle together the data in XML and CMS signatures? The answer is that for these formats, eIDAS implementation decision requires the use of the Associated Signature Container Extended or ASiC-E standard. The idea is that this is a zip file with some directory structure where we can store together the signed files, signatures, and metadata. Here is an example ASIC signature container. So it is a zip file with this MIME type. The most important file here is this document.6 in the root directory, which is actually the file that has been signed. There can be several files that are signed. The metainf subdirectory contains one or more signatures. So here you see that there are two signatures. So a signature is added by adding a new signatures XML file. The MIME type file here is always present and contains this MIME type inside it to denote what type of content this zip file contains. The MIME type file must not be compressed. The meta folder, there must be a manifest XML file which has to list files that are in the root directory. It also specifies the MIME type of these files. Now let's look at how the signatures in these XML files are encoded. This is an example of a real signature file. It has been shortened, some elements have been removed to make it to fit on a single slide, but the most important elements are visible here. So there are a couple of things to observe here. The signature is cryptographic signature. For example, the RSA or ECDSA signature value itself is this base64 encoded value. So to encode binary blobs, the base64 encoding is used in XML. The data which is signed is the XML signed info element right here. So literally this ASCII string here is what is signed from here to here. To be more precise, the canonicalized version of this XML element is signed. Canonicalization is needed because this is XML, and XML output can have different forms with the same semantic meaning. For example, we can have here an extra space character or an extra new line. It will not change the meaning of the content, but the hash value of the content will change. So the XML has to be normalized before signing and verifying the signature. Now, this signed info element contains signature method element which specifies RSA SHA-256 here, which means that this signed info element was canonicalized, a SHA-256 hash was calculated on it, and the digit file structure containing the hash value was signed using RSA, and the signature value was put here in the signature value element. Okay? The signed info element contains hash values of two other important XML elements. The first is the document that is signed, so this hash must match the hash of the file named document.six that resides in the root directory of the zip container. The second hash is the hash of the signed properties element, which contains some signed metadata. So this signed properties element contains several important fields. For example, signing time, which is the self-reported computer time at the time of signing. If the computer time was wrong, then this time will be wrong as well. It cannot be set to, so basically it can be set to future or backdated, so we cannot trust it. Then there is hash of the signer's certificate. The certificate itself is here in this unsigned element base64 encoded there, but the hash of it is here included under the signature. The reason why the signer's certificate has to be included under the signature is because the signatory could have several different certificates associated with the same public key, but which contain different identities, for example, different affiliations. If the certificate was not included under the signature, an attacker could replace the certificates after the signature has been created, effectively changing the signatory's identity. This requirement also prevents a signature from being created before the certificate is issued. For example, if an ID card manufacturer has access to the ID card in the card production phase, the manufacturer cannot use it to forge signatures before the certificate is issued for that ID card, right? The signed properties element also includes metadata that can be filled in at the time of signing, such as signatory's role, the place of signing, and resolution. And then every signed file has to have a data object format element which specifies the MIME type of the document. Ideally, the MIME type should help the relying party to understand how to interpret the signed file. Without the MIME type, there is some legal uncertainty of how relying parties should interpret the signed file, what software they should use to view the content. Let's say, what if we open this signed file with Microsoft Office and it shows one statement, but if I open it with LibreOffice, it shows an opposite statement. Which statement then expresses the signer's will? Unfortunately, in practice, signature creation applications set MIME type to application octet stream, which denotes a binary blob and does not really help. This means that in practice, relying parties have to use a file extension to figure out how to open and interpret the signed files. So, By signing this signed info element, we indirectly sign all files in the root of the zip container and the signed properties element, which in turn contains a hash of the signer certificate. If something was modified here, the hashes would not match and signature verification will fail. As you see, different hash functions can be used for every hash element and signature, so the security here also depends on the collision resistance of the hash functions used. As we discussed before, the cryptographic signature is not enough to verify the validity of a digital signature, because we don't know if at the time of signing the certificate was valid or not. We have to add a timestamp and a valid OCSP response. So these here are the XML elements where these responses along with the CA and TSP certificates can be specified. To conclude, this is how a XAdES signature looks. Every signature is added in a separate XML file such as this, and they do not depend on the previous signatures. So it is possible to remove one without invalidating others, which is not the case with paper signatures, for example, because we cannot remove an already given paper signature, right? A bit of historical perspective. Those of you who are Estonians, you may have seen BDOC and DDOC signature formats. So how are they different from the ASIC-E XAdES format that we saw on the previous slide? They're very similar, but there are some differences which make them eIDAS non-compliant, which means that these signatures will not be recognized by other EU countries. Let's start with BDOC. It is still used today. The only difference between BDOC and ASIC-E is that BDOC does not contain timestamp. In BDOC, an OCSP response also serves as a timestamp. Now you may have a question, how can we use an OCSP service as a timestamping service? The answer is that we can include the hash of the data we want to timestamp in the OCSP nonce extension. The signed OCSP response will contain our hash and timestamp in the produced at field, effectively binding the hash value to the time, right? So the hash of signature is included in the OCSP nonce extension. This is a smart hack. The problem, though, is that this hack is not recognized by eIDAS standards. eIDAS standards require the use of a separate timestamping authority with clear security requirements. For example, timestamping servers have to retain all issued timestamp responses, while this requirement does not apply to the OCSP service. So if you send a BDOC file to some other country, it most likely will not pass validation with the software they are using. Therefore, you can use BDOC only internally in Estonia. And that's why it is not preferred anymore, and DDOC software has removed the option to create BDOC signatures. Now, DDOC was the first file format used in Estonia from 2002 to around 2017. It is a single self-contained XML file, so no zip container is used here. Signed files are base64 encoded and stored in an XML data file element. For hashing, DDOC supports only the SHA-1 hash algorithm, which today is not collision resistant anymore, so there are security concerns which led to the deprecation of DDOC. Just to note, the same as for BDOC, the DDOC format does not have a separate timestamp. The OCSP response serves as a timestamp. Here you can see an example of a DDOC file. So the signed document is base64 encoded and embedded here in the data file element. Loading such a blob in an XML parser may require a lot of random access memory, so there are some size limits on the files you can sign using DDOC. Now the homework task is to implement an ASiC-E XAdES verifier. Implement a utility that verifies ASIC XAdES digital signatures. ASIC verify .py, which takes a single argument, the file name of the ASIC file it should verify. It will show the signatory's name extracted from the certificate, the name of the signed file, the date from the timestamp, and will perform all types of checks until finally it shows signature verification successful. This good ASIC file is provided in the course repository. This signature has been created using the Estonian ID card. The course repository also contains several bad files which are forgeries and must not pass the verification. For example, this forgery 1 ASIC should return the error that a wrong certificate hash is included under the signature. In total, there are 8 such bad signatures in the course repository. Now, these files must not pass a successful verification. You have to figure out how they are broken. The requirement is that the error messages have to be meaningful and unique for each of the forged files because they are broken in a unique way. The solution must support only a single signed file and a single signature, so you can hardcode the file name that is read to signatures 0 XML. The solution must support only the algorithms that are used in the provided test case files. It is not required to verify signatures on the certificates, timestamps, and OCSP responses. This would involve verification of the entire trust chain, which is too much work for this homework. Some notes. Note that the hash is calculated on a canonicalized version of the XML elements. The canonicalization code is provided in the template. You just have to pass in the XML and specify which element in canonicalized form you want to get back. Okay? What is perhaps not very intuitive is that digest info of the canonicalized signature value element is timestamp and not the signature bytes directly. Take this into account when verifying the hash in the timestamp. Code for parsing timestamp and OCSP response is in the template. Use zip file module for reading zip container. First import zip file module, open zip archive and create archive object. Then the files can be read using the read method on the archive. Okay. Use Beautiful SOAP for XML traversal. Import the module. This will create a Beautiful SOAP object from an XML string. And then you can traverse elements in the XML tree using this approach. The encode contents method will return everything that is inside the element between the opening and the closing tag. To access attributes of the tag, you can use this approach. Then you can search for a tag that contains some specific attribute values. For example, here searching for a reference tag with URI attribute containing this value. Okay? All right. So that is it for the homework. And this is it also for the lecture. Here are some exam questions. Good luck with the homework.